Good morning. Good morning, everybody. Happy Friday. Hi, everyone. As you are tuning in, say hi in the comment box. Let me know where you are logged in from. And let us know that you can hear us and you can see. I'm going to wait for a couple of people to get in on YouTube and Facebook. Good morning, Instagram. Good morning, YouTube. Good morning, Facebook. I've missed you guys. I know I haven't been live the last 2 days. I have been busy going to USCIS for interviews with clients. I was like, I got to come on here today before the weekend. TGIF. Good morning, Sarah from Philly. Thanks for tuning in. Okay, today I really just want to, answer frequently asked questions. So the floor is open. Most of the time I come here with a topic to talk about. I have the floor opened, and I want you to ask me your questions because you guys DM me all the time. Ask me your questions. So today's your opportunity to just ask me your questions. I'm not going to talk about any topic. I'm going to ask you your questions. Good morning, Jude. How are you doing? Thank you for tuning in from YouTube. And I also wrote a couple of questions. Good morning, Roxanne from Daytona. Thank you for tuning in. I also wrote a couple of questions that, I get asked all the time. So I just wanted to try and answer some of those questions for you guys, but please don't be shy. Leave it in the comments. And I will try to answer your question. And maybe today I'll even try to do, if you're on Instagram, I am going to try to figure out how to go live. You know how like you can request a video, whatever. You can try it today, and I'll see if I can figure it out because I want to learn how to do that. So we'll see if it goes live. Wealthy Sumley, good morning, Sunday. Accessible, good morning on Instagram. Good morning, Hydras on Facebook. Okay, guys. So let's ask questions. Ask me your questions. I'm going to talk about some questions that I've been getting recently. So one of the questions I've been getting recently from a lot of people is, why is the work permit 2 years? Like, I only got a 1 year work permit. When did this happen? So I talked about this a couple of weeks ago. But a couple of weeks ago, the current administration decided that as a way to, reduce the backlog, and overload that U.S. immigration is dealing with, that any new work permit that is issued, I don't remember the exact date. I think it was a couple of weeks ago, sometime in June, mid-June, like I think around June 20th or June 21st, any new work permit issue, but don't quote me on the exact date. It was sometime in June, but I can verify that for you and put in a comment later. Anytime in June, if you get a new work permit, it will be a 2-year work permit. It will be a 2-year work permit. And the reason why they're doing that is because they're seeing that a lot of cases are taking longer than a year to adjudicate and to make a decision. And every time people submit new work permit applications, new travel applications, it wastes time. It wastes time. It creates a backlog. So right now it's like, let's just give them a 2-year work permit because we know that, at least that covers the time while their case is pending. And hopefully maybe that way things will be able to move quicker. Okay. Okay, I see somebody. Let me see. Somebody just sent me a request to go live. Let me see if I can do it. Go live with Lori. All right, Lori said on Instagram, are you able to join me live? I just sent you the request. So, I'll wait for you. Oh, there you go.
Hi, good morning.
Hi, good morning, Lori said. Where are you tuning in from?
I'm living in South America, Guyana.
Guyana. Hi, how can I help you?
I was inquiring about persons that were deported for substance abuse cases.
Oh.
What's the option if possible?
Yeah.
Return permanently. I have a 23-year-old one American child.
Yeah.
I also have relatives in America also.
Yeah, so the thing about deportation is that, there are different categories of deportation where, you have to stay out your time for like at least 10 years. And then there are situations like what you're dealing with, that you're dealing with what we call a permanent bar. So it is going to be really unlikely, unless something changes when you're deported for what they consider aggravated felony. So aggravated felony doesn't necessarily mean that it's a physical violence. It's just what USCIS considers um, as such. And drugs is something that it's punished very heavily and severely, in the United States. And so because of that, you really don't have any options, if you're looking at a permanent bar. I mean, you could try to do an I-130 and try to do a waiver, but the odds are you're probably not going to be approved for the waiver, unfortunately. So unless something changes, with the administration, right now you're just going to have to be in a pending situation, unfortunately. Okay.
Okay.
All right.
Thank you for your time and information. Have a blessed week.
You're welcome. And then you can turn this off because I don't know how to turn it off. You can just log out. Okay, so let me answer the other questions. Let's see. Okay, so Sarah says, please explain the difference between a 601 and a 601A waiver. That is a good question. So a 601A waiver is a hardship waiver. And what does that mean? A hardship waiver basically means this, that you are in the United States and you've overstayed your time, or you entered into the United States without inspection, right? And you're either married. So if you entered without inspection, you can adjust your status here, whether or not you're married to a U.S. citizen, whether your child is a U.S. citizen, unless you qualify for VAWA. What has to happen is you need to get a hardship waiver. I'm going to explain in a second. I just want to give the breakdown. And then for those who enter with a visa and overstay their time, but they end up marrying a green card holder, not a U.S. citizen, a green card holder, they also cannot adjust their status here, right? Another category of people that this may fall under are people who come here on a crewman visa, like a C1 visa, where they're here for a cruise ship, is supposed to be sailing through, but instead stay here and then they marry a U.S. citizen. They also cannot adjust their status here. So for those people who can adjust their status here, what happens is that relative can file an I-130 petition for you. When that I-130 is approved, because I-130 is essentially just approving the fact that, okay, we agree with you. This is your relative. This is your husband. This is your wife. This is your child. But what happens next is that you then have to submit a 601A hardship waiver. And in order for you to submit a 601A hardship waiver and to prove that you have to prove that you have a U.S. citizen parent or a green card holder parent, or a U.S. citizen spouse, or a green card holder child, or a green card holder spouse. There's no child here. It's only parents or spouses that will suffer either financially or medically or psychologically or emotionally if you're not able to return back into the United States. And if they approve you for your hardship waiver, then once your hardship waiver is approved, they will then schedule you for your interview back in your home country, and then you can go back and do your interview, and God willing, there's nothing else making you inadmissible, then you can come back. Whereas a 601 waiver is a catch-all waiver. So it covers fraud, misrepresentation, I lied on this, I did this, and I did that. A lot of times you can file a 601 waiver while you're within the United States. If something happened, like if you lied on for the purposes of immigration, you can attempt to file a 601 waiver, or they can tell you that you need to file a waiver. Again, or if you misrepresented something, again, it's going to really be dependent on what the misrepresentation is. Because there's certain things that you can't waiver it out. Like if you ever claimed to be a false, you ever claimed falsely to be a U.S. citizen, you cannot, there's no waiver for that. So please don't ever do that. I know that there are people that work under the table or whatever it is, but don't ever claim to be a U.S. citizen. You know, if you work under the table and you never claim to do that, if you're married to a U.S. citizen, usually they're going to forgive that. But if, as long as you claim to be a U.S. citizen, it's a no-go. So those are the differences, you know. So one is for hardship, one is for misrepresentation. Sometimes if you're outside of the country and they determine that you misrepresented something on maybe years ago on your B1, B2 visa, that's your tourist visa. So they may say, we're not going to approve you, but you're eligible for a waiver, a 601A waiver. So what ends up happening is then you now have to submit the 601 waiver. If that waiver is approved, then you'll be able to get your visa to come into the United States. So that's the difference. It's a bit complex. The 601s are a bit complex, but that's kind of what it is. Okay, so let me see what other questions I have here. Okay, somebody says, good morning. If someone's adjustment of status gets denied, what will be their current status when applying for TPS? No status. So you don't have any status. It's considered no legal status. So that would be what would make you eligible for TPS, because, you know, if you already have a green card, then you're not eligible for TPS. Good morning, Lily on Instagram. Somebody says, I filed for valid case only in December 2008. 2008? Until today, you've not received either a prima facie? Yeah, Michael, you need to call me. Give me your receipt number. That's crazy. That's crazy. 2008. Are you sure? Is that a typo? Did you mean to type 2018? Anyway, give me a call, 407-995-6567. Let's see what's going on with you and your receipt number, okay? All right, let me take this call from this question from YouTube. Ariane says, I'm filing for adjustment of status and my wife filed as head of household on her last taxes. Will it affect my paperwork? So not necessarily that she filed head of household, because at this point, I'm assuming that you probably don't have a social security number and you're essentially, you know, either undocumented or you're an overstay here. Where it becomes a problem is once you get your social security number, and once, you know, it's time for interview and your spouse is not claiming married filing jointly or married filing separately, that's when it becomes a problem. But again, remember, joint taxes are not the only things. Yes, it is a good thing to show a bona fide marriage, but there are other things that you can use to show a financial relationship with your spouse. So that in and of itself is not going to be the thing that breaks your application process. That being said, if you guys haven't been married for over 2 years and you end up getting a conditional green card, make sure that when you do get that green card that you guys are always filing together or married filing separately, not head of household and not single at that point, because they're going to say, you know what, you have your social security number, so why aren't you guys filing together? Okay. So Jude on YouTube says, I just got divorced. Do you think I can get married real quick with the woman I have now, but I ain't got no kid with her, but she's a U.S. citizen? Jude, that is up to you. I can't tell you to marry somebody or not. You know, if you want to get married, you can get married. There's no timeline to when you can remarry somebody when you get divorced. Just make sure that whoever you're marrying, that you're getting into a legitimate marriage. That is the key. You know, as long as you have a legitimate marriage and you can prove you have a legitimate marriage, all USCIS cares about is you proving that. Okay, let me see. I think I have another request. Okay, Lily has a thing. So let's see if she can join us on video. Lenise says that she applied for citizenship but didn't know that. Oh, okay. So here we go. Let me do Lily. Hi, Lily. How are you? Good morning. What's your question?
My question is that I filed for I-130.
Mm-hmm.
I filed for I-130 since 2020. Then it's only I-130 that I filed for. So I went for my biometrics March. So since then, I've not heard anything from them.
So you filed in 2020?
Yeah, 2020.
1 month.
July.
July? And the last thing you heard was in March for your biometrics?
Yes.
Okay, so one of the things that you can do is if you look on your filing receipt, on the bottom left, you're going to see your processing center. So depending on where your processing center is, you can actually go online and see the dates that your processing center is at. Like, so that will tell you where you are in the timeline, and if yours is coming up soon. And then if yours is or has already come up, and it's been more than 6 months, because you did your biometrics in March, I wouldn't say you're eligible yet to do any service inquiry. Honestly, like some processing centers are taking like up to 12 months right now. From due to the biometrics, or 15 months. Hopefully that's not your case, or even 20 months. So check the processing center, see where they are. And then 6 months from March, you can do a service inquiry by calling USCIS just to see what's up. It's been 6 months, I haven't heard anything, and hopefully that helps to move your case forward. Okay.
Okay.
All right, and then you can hang up. I don't know how to hang up this thing yet, but you can go ahead and hang up. You're welcome. So Patrick, okay, you asked for direct contact. Our number here is 407-995-6567, or you can send us a WhatsApp, 404-333-8751. You can send us a WhatsApp to call you, or if you have a US number, and we'll definitely give you a call to schedule a consultation. Okay, so somebody says that they filed for, okay, you corrected yourself. So you filed for VAWA in 2018, and you've not received either a prima facie or final decision. Well, that is concerning. You want to make sure that you actually did file. So call me. Yours is not one that I can discuss on live, because I have to evaluate your case and see what was submitted and when it was submitted. You might need to supplement your application, but that is definitely a long time not to have heard anything, not even a prima. That's actually very concerning. Okay. Somebody asked, what documents do I need to apply for VAWA? So the list is too long to go over on live. You can definitely schedule a consultation with me. If you schedule a consultation with me, and you do qualify for live, for VAWA, usually I'll send you a list. Okay. Somebody asked, does your name need to be on the lease for the initial submission of adjustment of status, or the person can wait until they receive their Social Security and work permit to add their name on the lease? So there's no requirement for anything with immigration. The requirement is that you show you're married. So if your name can be on the lease, then put your name on the lease. If your name cannot be on the lease, then put your name on the lease when it can be on the lease, or have other things to show the legitimacy of your marriage, even if it's not on the lease. So there's no strategic timeline. The earliest you can get on the lease, the earliest you can show documentation of your marriage, the better for you. Okay. Fafo, good morning, Ralph from Orlando. We have good news for you, by the way. Let me see who else is here. So Jude, I think I answered that question. So Chan on YouTube says, I changed my adjustment case to a VAWA case in 2019. I've received 2 prima facies, which both expired. I filed for my renewal EAD in December, and I still haven't gotten it. What might be the cause? July. So you filed for your EAD. Honestly, I hope you're not just one of those unfortunate people that slips through the crack. If you filed for your renewal based on VAWA, your filing receipt should act as a temporary EAD. So you want to confirm that your filing receipt specifically says that. If your filing receipt says that acts as your EAD until you get a new employment authorization. Like I said earlier, employment authorizations are taking so long, which is why now they're giving them for 2 years. So that's what you want to do, because it's just taking long. I mean, December, you should probably have gotten it, but again, this is immigration. Sometimes you might just be one of those unlucky ones where your stuff is just taking so long. Fafa Beef asks, do I take divorce cases? No, I'm not a divorce or family attorney. But if you're in the Florida area, I'm happy to refer you to a good divorce lawyer. Let's see. What other questions do I have here? Okay, did I answer everybody's question? Let me see. What else I am missing? Okay, yeah, there are 3 other questions that I wanted to talk about that I get asked all the time. People ask me all the time, if I'm filing a vow petition, do I need to divorce my spouse? Do I need to stay with my spouse? What exactly do I need to do? So for you, the answer is that it is whatever you want to do. There's no requirements to be divorced, and there's no requirement to stay married. So you have to decide for you and your life and your family whether or not you should leave the marriage. So I can't give you legal advice, but personal advice, removing my attorney hat, if I'm in an abusive marriage, I would not stay in the marriage. Why would you stay in the marriage? You leave, right? But for people, and for many different reasons, they feel they need to stay because they cannot support themselves financially. And that is why filing a vow application is important, because guess what happens? If you file a vow application and you get a prima facie determination letter, a lot of times they'll be able to provide you with public assistance, financial assistance and housing, financial aid if you want to go back to school. And then ultimately you get your work permit. When you get your work permit, then you can get a job so that you can gain your own freedom. So that's really the answer. Whatever you think is best. Okay, I think I have another video thingy. Let's see. Okay, no, I think I answered that one. Okay, somebody asked, how much is your consultation fee? So for an evaluation of your case with me, I charge $800. And during your consultation, I usually try to, understand the history of your case or what you qualify for. I try to go over what you qualify for. If you qualify for something that is something that I can assist you with, I usually like to give the clients a document, which is a process and timeline that allows you to just understand from the beginning of your case to the end of your case what the steps are, so that, instead of asking, you can always go and check off the box to know where you are in the stage of your case. Yes, you can schedule an appointment. Actually, Fafa, you can call the office. I believe that we try to reach you today. So call us, call the office. Let's see. What other questions? Okay. Somebody asked yesterday if they must withdraw, if they have a marriage-based case and then their spouse becomes abusive and they want to file VAWA, do they have to withdraw their pending marriage-based case? So the answer depends on where you are in the process to determine what is most strategic. What I mean by that is, if, let's say, you've gotten your work permit, one of the things that I recommend is, instead of withdrawing, we do what we call an abeyance. An abeyance is like a continuance, where we're saying to USCIS, we're no longer going to be filing this I-485 on the basis of marriage. We're filing on the basis of vows. So please hold making a decision, hold scheduling an interview for this case, and separate my application from my husband's. And we remind them of the confidentiality clause. And, because it is a federal violation to violate a victim's right or to disclose to your abuser or to anybody else other than your attorney of record that you're submitting an abuse claim. If we do that, then you're able to actually merge your cases. If you just submitted your application and all of this craziness starts right after you submitted, sometimes it's better to just file a brand new application. The reason why is because abeyance, if you don't have a work permit, delays your work permit. And so in order not to delay your work permit, it's better to just file a new application. Okay. Elizabeth says, Maxine Spencer, come here. Yes, Maxine, get in here. Get in here. Let's see. What other questions do I have? Okay, so I have one more question. And who is this with the angry face? I see I have some haters on here. Why do you have an angry face on here? What's the reason for that? Anywho, as I was saying, so the last question is, who can you petition for? Who can a U.S. citizen petition for? Because I get this question all the time, So if you're a U.S. citizen, these are the people you can petition for. You can petition for your parent. You can petition for your children. These are as immediate relatives. So you can petition for your children under 21, unmarried, and they will be considered immediate relatives. If you petition for your children over 21, they won't be considered immediate relatives. So their timeline is going to be a bit longer. They're going to have to wait like about 6 years. You can petition for your spouse, and you can also petition for a fiance, outside of the country. And then lastly, you can petition for your siblings. Again, your siblings will be a family preference category. So you're going to be looking at like 6 years. I'm sorry, not 6 years, 16 years for your siblings if you do that petition. So those are the people you can petition for. And then if you're a green card holder, you can petition for your spouse. You can petition for your children under 21. Spouse and children under 21, right now the visas are current, so they're moving faster, meaning if you're in the United States and your visa you've not overstayed your time in the United States, you can actually file it right now with an adjustment of status for the month of August. Otherwise, if you've overstayed, you have to do it while they're outside the country. But again, visas are available, so they're moving quickly. But green card holders can also petition for children over the age of 21, but they cannot be married. So they have to be unmarried for you to petition for them. And their own timeline is taking about 5 years. So believe it or not, it's actually quicker right now to petition for your green card holder child that's over 21 than your U.S. citizen child that's over 21. I don't know why, but that's just what it is right now. All right, guys, if you don't have any other questions, I'm going to jump off. I hope you guys have a wonderful weekend. And I'll talk to you guys next week. Bye.